Distinguished guests, ladies and gentlemen, welcome back. I hope you enjoyed your meal and had a great lunchtime. So now let us begin the second session of the 12th Asia-Pacific ADR Conference titled Keep Up or Perish, Practitioner's Dilemma in the New Digital ADR Age. So first of all, I would like to invite our distinguished moderator and speakers of session 2. So if you're serving as a moderator or speakers, please rise and come forward and take your designated seats on stage. Ladies and gentlemen, please welcome them with a big round of applause. And for session 2, the Honorable Mr. Kabyu Kevin Kim, founding managing partner of Peter & Kim, will serve as a moderator. And we are joined by 5 speakers, including Madam Atita Kominder, head of the Ancestral Regional Center for Asia and the Pacific, and Mr. Chan Ho Kang, partner at Wong Partnership, and Mr. David MacArthur, co-head of International Arbitration at Anderson Mori and Tomosune, and Mr. John Rhee, Asia managing partner at Queen Emmanuel Urquhart and Sullivan, and last but not least, Mr. Matthew Christensen, senior foreign attorney at Kim & Chang. And finally, I am very pleased and honored to announce that session 2 will be moderated by the Honorable Mr. Kabyu Kevin Kim, who is a founding managing partner at Peter & Kim. So now let me hand over the microphone to him. So ladies and gentlemen, please welcome him with a big round of applause. Excuse me, sir, I think I forgot to introduce you briefly, so let me give you a brief introduction of our moderator first. Well, to give you this brief introduction, Mr. Kim is the founder and managing partner at Peter & Kim, and he is one of the world's leading dispute resolution professionals, and he is a key figure in the Korean arbitration market. And he is also currently serving as the chairman of the Korean Commercial Arbitration Board's International Arbitration Committee, and he's also an advisory board member for the ICCA, and he's also an adjunct professor at the Seoul National University Law School. I'm done. Now let me hand it over to him. Please welcome him again with a big hand.
Thank you. I'm a bit lazy, so I prepared something for my introduction and introduction of my speakers using AI. I did not do that. I'm lazy. So my senior associate, Samir Thakur, I found that he was a program engineer for several years before he became a lawyer. So because it's a free version, it's not really good, really similar to me and my voice. But what I want to make sure is that it is all prepared by AI with my request, including joke.
Welcome to the second panel of the Seoul ADR Festival 2023. I'm honored to be your moderator for this discussion on Keep Up or Perish, Practitioner's Dilemma in the New Digital ADR Age. I know we're all feeling a little bit sleepy after lunch, but I'm confident that this panel will be informative and engaging enough to keep us awake. We're going to be discussing some of the most important issues facing ADR practitioners today, including the impact of digital platforms, third-party funding, and AI. The digital age is changing everything, and ADR is no exception. New technologies are transforming the way we resolve disputes, and ADR practitioners need to keep up or risk being left behind. In this panel, we'll discuss the latest trends in digital ADR and explore how practitioners can use them to improve their practices and serve their clients better. We'll also look at the impact of third-party funding on ADR and the potential of AI to revolutionize the dispute resolution process. I'm excited to have such an esteemed panel of speakers to join us today. They're all experts in their fields, and I'm confident that they'll provide us with valuable insights on the future of digital ADR. Before I introduce the speakers, I want to leave you with one thought. The digital age is presenting ADR practitioners with both challenges and opportunities. The key is to embrace change and to use technology to your advantage. ADR practitioners who do this will be well positioned to succeed in the years to come. Now, without further ado, let me introduce our speakers.
How about that? Much better than me, right? Let me continue.
Athita Kominder is the head of the Uncitral Regional Center for Asia and the Pacific. RCAP provides technical assistance and capacity building programming to over 50 states in the Asia-Pacific region on issues related to international trade law. Ms. Kominder has over a decade of experience in the fields of international trade and economic law, arbitration, multilateral dispute resolution, negotiations and diplomacy, and the rule of law and development. I look forward to learning from her. Mr. Hock Keng Chan has over 25 years of experience in commercial and corporate disputes with a focus on international arbitration. He has represented clients in a wide range of arbitrations, including those under the rules of all major arbitration institutions. Hock Keng is a highly respected lawyer and arbitrator with a wealth of experience in international arbitration. He is a valuable asset to the arbitration community and a role model for young practitioners. I am sure that we will all draw great insights from his comments today. David MacArthur is the co-head of international arbitration at Anderson Mori and AMP Tomatsun. David is a highly respected arbitration lawyer and arbitrator with over 20 years of experience in international arbitration. He is a fellow of the Chartered Institute of Arbitrators and has been listed and/or appointed under the rules of many institutions. I had the pleasure of working with David at BAE, Kim, and AMP Lee for over 10 years, where he was an important member of our international arbitration team. I am delighted to welcome David to our panel today. I'm sure that he will share his insights and expertise with us, and that we will have a lively and informative discussion. We also have with us Matthew Christensen, Senior Foreign Attorney at Kim and AMP Chang. Matthew is a leading international arbitration practitioner in Korea, with over 20 years of experience in complex cross-border disputes. He is a fellow of the Chartered Institute of Arbitrators and has been listed and/or appointed under the rules of many institutions. This feels almost like a reunion because just like David, Matt, and I, in fact, all three of us, worked together for over a decade. I am delighted to welcome Matthew to our panel today. I am sure that he will share his insights and expertise with us and that we will have a lively and informative discussion. Our final speaker, Mr. John Rai, who is the Managing Partner of Asia for Quinn, Emmanuel Urquhart, and AMP Sullivan. He has decades of experience in international arbitration and has worked for leading arbitration practices all over the world. His career has been defined by a commitment to excellence, innovation, and a profound understanding of the complexities and opportunities within the Asian legal domain. Please join me in extending a warm welcome to all of our speakers. I will now give the floor to our first speaker.
Sorry about Beckham and Lee and John Lee. They say I have problem in pronouncing Lee. Actually, our first speaker is John Lee, rather than the last speaker. John will introduce the general issues of AI without using any PowerPoint, which is quite AI-like. So, John?
Thank you. I don't know how to follow that that up, but I'm not anti-AI, but I'm pretty technologically backward. As you can see, my notes are hand scribbled on this. I still use a BlackBerry, which I think is pretty uncommon. It's about to explode very soon because it can't take it doesn't do 5G, it barely does 4G. But we're here now, I think, in this world of technological advance. I think when we used to talk about AI, certainly I wasn't too much aware of what ChatGPT was, certainly 3 years ago, maybe a little bit 18 months ago, and now it's part of our lexicon on a day-to-day basis. I think with the explosion and how AI and technology affects us in the legal industry, disputes industry, it obviously pervades through much more than that. It's really going to be, and it's already everywhere. And so there are undeniable opportunities in relation to that. And who knew I'd you start thinking that Arnold Schwarzenegger in Terminator is actually a possibility now as well. So there are undeniable problems or potential problems if we don't deal with these issues properly. And now those are global, high-level issues that go beyond what we just do. But I think in relation to what we do, I think in relation to AI, you know, some form of technological help has always been around, at least during my time. Even a BlackBerry at some point was very technologically advanced. But I think now we're seeing things which I had not seen before. And I had to ask some of my associates about what are the tools that are out there. And they've told me a couple of things. And obviously, Chris mentioned in relation to Microsoft what's coming. And I think most of us use Microsoft and Outlook. And it's not a choice anymore. I mean, it's going to be there. Whereas I think if you see IBM's Project Debater, I wasn't even sure what that was, but I'm told that that assesses the persuasiveness of an argument. So you can put into that debater system what arguments that you intend to put forward in a potential case, and it will tell you the strengths and weaknesses of that argument. There's also something called arbitration tech, which extracts meaning from documents. For instance, it can identify or what it perceives as things which don't seem to be true or dishonest within that case. And so I think where we are now is, you know, there's really no stopping it. It's happened, it's happening. I'm clearly very backward. I'm very, very backward compared to most of us here. But I think it's a realization that it can be very helpful. But I think the two things that I'm seeing in the real world in how it could affect people and businesses in the legal industry, I'd say number one, in relation to AI, the most obvious things that can happen as a consequence is you have to query, especially in a US-style litigation or an arbitration where there's discovery and disclosure. Do you need a human to do that? Do you need a human to really review things? Maybe at a high level, but on a day-to-day level, you know, the revenue generation of a firm generally is an hourly model. And if that goes as well, then that's a real issue to think about as a business. But also on a human element, growing the associates into more senior level lawyers. How does one end up doing that when the junior level work may no longer be that necessary for a human to do, or humans to do, where they get their hands on documents and review and so on and so forth? That, I mean, we are coming to a very, I think in the near future, a real debate as to the necessity of a pool of junior associates doing research, for example, when you can have technology being able to pretty much, I think, find all the documents, and it's for someone else to review, and all the cases, and it might be someone at a more higher level to review. But how do you become more experienced and more senior when the junior associates may not be as necessary anymore? The real input and the real value of non-AI may be someone who has a great deal of experience and can have the human touch, whatever that may mean in the future. And if you don't have the basic strength and knowledge, having grown from reviewing things and drafting things, there is going to come a time where there's a bit of a bottleneck, where the very senior people are highly sought after, but it becomes harder to become that senior person. And then I'll end with, I think, the last point, which is data privacy. I mean, that is, I think, a large issue, not just for the law. And, you know, we're involved in some of these cases where you never thought about a year ago you'd have adversaries like, you know, you have Reddit against OpenAI now, because OpenAI is mining data, and Reddit is meant to be a community that is for certain people who've agreed that this will be amongst themselves, confidential. But there's a huge amount of data. I mean, Reddit is just an example. Of course, there's a huge amount of data in the internet. But in relation to that, how do you then deal with those issues and all the information that you want in order to use in the legal forum? So if I want to look at all the cases or look at all the arguments, where are they coming? They're coming from somewhere, and it's someone's. And so those are issues that I think will be touched upon, but I think my time is up. I think my colleagues will be talking about things in more detail, and I think, Kevin, I think you wanted to have a debate, so thank you for that. Thanks.
Thank you, John. Let me ask one particular question. What if the two parties just agree to arbitrate only by AI without human being? Is such an arbitration agreement enforceable under English law?
Can we have that AI bot again? Because that was much easier than, than this human question. I think that question probably is early in that we'll need a completely new framework, I suspect, from the New York Convention to international arbitration rules in dealing with it. I'm from an English law background, so if we use the English Arbitration Act, the premise that you mentioned, Kevin, is party autonomy, right? We can agree to flip a coin. It's not necessarily an arbitration. We can flip a coin and decide. Is it actually enforceable? That's another issue completely. Because the laws on arbitration, and most laws, haven't dealt with the fact that the deciding entity might be a non-human, there might be a problem, because I think some sections like 25, 26 of the English Arbitration Act dealing with arbitrators, they talk about resignation, they talk about certain things with liabilities, certain things which are human related, death, right? If an arbitrator dies, what happens? What does that mean with AI? Someone pulls the plug and the AI is a problem. And I think the other main issue is with AI, and this is a global issue. People are worried that jobs will be lost, but jobs will be certainly gained. This is the part of history, right? Like something goes and something comes back. It's the way of the world. But the key people are going to be what I understand are called prompters, right? People who are putting in the data to the AI. And so this is going to be the critical junction, I think, where is the prompter a part of this AI arbitrator or panel? What is AI? What is this AI machine being able to do? So, like I always like to answer a question. I think to answer your question, I mean, you can do it, right? Of course you can do it. I think it'll probably have some serious problems in relation to enforcement. If we had that weird quasi-Kevin Kim looking person there, first of all, it would freak me out. But secondly, I think it would be, as you say, party autonomy does trump a lot of things, but the rules just simply don't, in my view, legislate for being able to do this where it's enforceable or recognizable in various jurisdictions, including England's. But annoyingly, that was a good question.
Okay, very, very good answer. Any contribution from other jurisdictions?
If I can't get this right. Okay. Well, I think that it would be a live issue in a lot of jurisdictions. I would just simply point out that there are some jurisdictions in which it would be very clear that the arbitrator needs to be a natural person. And so then this gets into the question of how do we accommodate the use of AI. My own view is that, as was the case with, say, dealing with accommodating third-party funding in some jurisdictions that had existing rules concerning champerty and maintenance, they have found a way to accommodate when it made sense to the community to do so. And I suspect we'll be looking at the same thing. But certainly there will be adjustments that will be needed in probably most jurisdictions, I would have thought.
Okay. Now could you move to using the database or the online arbitration functions? Adita?
All right. So I would like to start with my presentation on Antitral's project on dispute resolution in the digital economy. But first, can I say I envy your use of AI very much, Kevin, because one of the underlying principles of Antitral in our work in digital economy is technological neutrality. So if I had tried to use one AI platform, I probably would have tried to use them all. So, but thank you very much for that illustration. Also, before I start, in response to John's point about human prompters, I totally agree. Antitral's recent experience with using AI informally to automatically translate one of our two-day conferences actually required human prompters to correct a lot of Antitralese. For example, it kept translating one of our instruments, the MLETR, Melita, when in Chinese, I think it might mean the devil or evil, I'm not quite sure. So human prompters are still very much needed, but they were amazing to see how they were able to do it so quickly. So it is issues like this and others that Antitral is taking stock of in the Dispute Resolution and Digital Economy Project, which in Antitralese is DRDE. So the importance of developing a dynamic cross-border legal framework for the facilitation of international trade and investment, especially in this new world, no map context that we're looking at, can't be overstated. Which is why the DRDE project might be a useful way to further set the scene for this panel's discussions. So as background, the impact of digitalization is seen across the board, and dispute resolution is no exception. And in response to this, as proposed and funded by the government of Japan, the DRDE stock-taking project was launched by Antitral in 2021. The commission conferred on the Antitral Secretariat the mandate to monitor the changing landscape of dispute resolution in the digital economy. What we are specifically mandated to do is to take stock of the latest developments in dispute resolution through compiling, analyzing, and sharing relevant information. And as Antitral is a legislative body, as mentioned this morning by both Anna and Jay, these activities are carried out with a view to updating existing texts or developing new ones if there is appetite or if there is need. The focus of the project is twofold, which could be characterized as negative and positive. On the negative side, the focus is on the disruptive process, disruptive aspects of digitalization, especially those on due process and fairness. On the positive side, the focus is on the enabling aspects of digitalization insofar as its impact on cost and duration and other things is concerned. Let me just, yes. So these are examples of some of the questions that are being explored and discussed in the DRD project so far. Our morning panel, I think, looked to some extent at the first three questions, and this panel session will, I think, be focusing on the last two, which are quite fascinating. So where are we in terms of the use of AI, specifically AI-assisted decision-making, which Kevin already foreshadowed, and what are the parameters of dispute resolution on online platforms or blockchain? So I think I will be elaborating on that more during the discussion so as to give you a more general overview now. So in light of Antitral and also United Nations practice, of course, ensuring comprehensiveness and diversity of views is key. We also heard about that this morning. The Antitral Secretariat has therefore embarked on an initiative called the DRDE World Tour to seek inputs from different parts of the world comprising different legal traditions and economic systems. And our discussions have been held to date in Tokyo, New York, Guatemala City, Paris, Vienna, Abidjan in Côte d'Ivoire, and Singapore. And as with all other aspects of Antitral's work, gender dimensions and considerations are also taken into account in the DRDE project. So for example, with regards to access to technology, and also for artificial intelligence. For example, there might be some bias in the use of, in building stereotypes that the AI might rely on. So UNCITRAL has published 2 documents on DRDE so far. This is the extent of my high-techness. So you can download the documents if you're interested in reviewing via QR code there. A caveat is that the contents of the documents are of a preliminary nature, but they could be interesting for those who are following this issue more closely. In addition, UNCITRAL has recently published a taxonomy of legal issues related to the digital economy, which documents the exploratory work carried out by the UNCITRAL Secretariat across a range of hot topics, notably AI, data, digital assets, online platforms, and distributed ledger technology. The taxonomy analyzes each of these topics from an international commercial law perspective by defining the topic in legal terms and identifying the actors, legal relationships, and legal issues involved in the deployment and use of associated technologies and applications. So if you're interested, you can download that for free on the UNCITRAL website. It's currently available in English, but will soon be available in all 6 of the United Nations official languages. So with that, I end my overview here. Thank you very much, Kevin.
Thank you, Adita. Among you said just 2 important questions that UNCITRAL discussed. Let me ask one question. What are the parameters of dispute resolution online platform or blockchains?
Thank you for the follow-up. So in the DRD project, the term dispute resolution platforms is broadly defined to include not only the so-called case management platforms which people are familiar with, but also technology-enabled services such as video conferencing platforms and also on-screen digital presentations. In the DRD project, there has been discussion about the specificities compared to offline interaction and the need for measures due to address those specificities. So in essence, ensuring due process, fairness, confidentiality, and integrity of the proceedings are key. I have some examples. Did you want me to go into that now or maybe later?
Yes, please.
Okay, thank you. Thank you. So let me just give you one example. So certain new technologies relating to on-screen digital presentations have also been discussed in the context of the DRDE project. For example, in construction cases, 3D modeling may be used to make visible objects that would otherwise remain unseen, such as those underwater. 3D modeling, of course, is a process which creates a 3-dimensional representation of an object or surface by using specialized software. Another example is virtual reality technology, which might be deployed to replace on-site visits by using a combination of software and devices like headsets and sensors to create a 3-dimensional environment, simulating an environment approximating reality. But in leveraging these technologies for on-screen presentations, it's cautioned that there's an accompanying risk of manipulation. So the technology could be misused to include information that is not supported by evidence. And to address such risk, the parties could either jointly put forward the presentation or share the presentation with the other party to provide an opportunity for its review and for it to raise any disagreements it may have. So those are some of the issues, examples that we're looking at. Thanks.
Okay, thank you very much. It's very helpful. Anybody have any experience using this type of 3D dimensions or virtual reality? I never used that in my practice. Okay, Hokan, could you introduce how we use AI in international arbitration?
안녕하세요. Good afternoon, everyone. It's nice to be back in my favorite Asian city, away from home. On the topic of AI, I wanted to do a live demo of how some of my juniors are using generative AI to ease their never-ending workload. However, as I'm like John, IT dinosaur, And for the fear of hiccup, I decided that he will make a short clip for me, my associate. This is just to show what they use, AI, to perform some minor tasks for the team. In the clip, he's going to use Google Bart and to generate a draft notice of arbitration based on certain documents that are put into his file. Do forgive me if your IT level is much higher than mine, as the clip is meant to be a very simple illustration for the less tech-savvy adjusi lawyers like me. Can someone play the clip, please? It was meant to be some keyboard typing sounds, but I've gone. Yeah. So sorry that this is quite a simple draft, and I just noticed that the last search that my associate did was how much caffeine you drink before it comes lethal on you. So I will give him a day off when I get back. And can I just put on the slide? Yes. So what I will try to do in my few minutes is to maybe give my take on what is available today on AI and what might happen in maybe 5 years' time. It's just my best guess. Ever since the science-fi guru, Mr. Isaac Asimov, invented the 3 laws of robotics, that's in 1942, more than 80 years ago, and he predicted that robots and AI will take over the humans, and it's the rise of the machines. And he said, we must have a strict moral code implanted into the machine's DNA so that humans will continue to exist. And perhaps for lawyers, we can copy that law of robotics and have, we lobby our government for the 3 laws to protect lawyers. First law, AI must not replace lawyers or cause their jobs to be in jeopardy. Second law, AI must continue to improve lawyers' productivity unless this will conflict with the first law. And the third law, AI must protect its own existence as long as protection does not conflict with the first law and the second law. And will us lawyers be the first wave of the casualties? No one knows. The key question is whether AI can make our work as arbitration lawyers and arbitrators faster, better, and cheaper. I think faster and better is a given. Faster and cheaper is a given. Whether it's better that's the black box. AI-powered tools are already helping lawyers with a variety of tasks that's been mentioned by Chris and other speakers, including legal research, document review, data analysis, and automating the tasks. AI-powered legal research tools can help lawyers save time, find more information. They can summarize authorities, highlight cases, identify patterns in the law. There's many in the market, Ross Intelligence, Thomson Reuters has some, Lexis plus AI, Westlaw Edge, Co-Counsel. Just Monday had just launched a beta version of Just AI, which could summarize arbitral awards. So for document review, AI-powered document review tools can help lawyers review large volumes of documents more efficiently and accurately. And you might remember that in the 70s, we started to have spell check, and that was like, wow, No more spelling bee contests anymore, it's spell check. But now it's natural, right? You know, prompting, guessing what you want. And these tools can flag common errors, such as definition issues and updated terms. They can highlight important points and important information based on prompts. You can generate timeline of changes on document, compare changes to an arbitration across multiple drafts. Data analysis, powered data analysis tools can help lawyers make better decisions and develop stronger arguments. There was a suggestion that about debating tool that you can say by John that they tell you how good your argument would go down with the tribunal. And discovery tools, there are tons out there. And automating of tasks. So AI-powered tools can automate lots of tasks, scheduling appointments, creating calendars, drafting very routine documents. This free up the lawyers to do more important and strategic stuff. And Chris mentioned the Microsoft Outlook's AI-generated prompts, and that's something that we will all have to deal with the next 5 years. The future, what can the AI do for lawyers in 5 years' time? It's a difficult question, but we can all dream. I believe that infant example of the AI tools is, in the future, we could just dump everything into the AI machine and they will create everything. The statement of case memorials. AI will be able to interview witnesses and draft witness statements for the parties. And we probably don't need tribunal secretaries anymore because the AI can do the same task that the tribunal secretary is doing, as in drafting the awards. And AI should be able to provide nuanced advice and propose settlements by putting all the data into the software and tell you what the chances of winning on the case, how much cost you incur at various stages. And we know that AI tools are fast, accurate, cost-saving, and that's all the craze for the future. And like most of the speakers before me, I don't think AI will make lawyers redundant. It will make lawyers that do not embrace AI redundant. So the message is we should all learn. Like I'm talking to my associate like every day now about what he can do, and I want to learn more about it. Thank you.
Thank you, Ken. Maybe you can think about step by step. Yeah, of course we can use AI for for convenience, searching the documents, analyze documents. I remember that one case I our side submitted 900 pages written submission with 100-page summary. And if the tribunal receives such a voluminous doc in submission, they are quite tempted to ask AI to summarize it. Please summarize it within 5 pages or 10 pages. Then if this became practice, then we counsels have to think about or like to some rehearse how the AI summarize our submission in 10 pages or 5 pages so that my key points are not missing in the summary. So we have the issue whether or not how much the tribunal disclose how much I used AI in calculation. Same applied to the institution review. ICC or the other organizations have the review of the word, but they can do that. AI can review the word very quickly, check all the calculation, logical value, whatever. How much we can use it? Is any insight about anybody?
Talking about the extent to which I think it depends on your role, right? And probably with lawyers, we're saying as much as possible, as much as we can. And I think there are some potential restrictions on the extent to which arbitrators can, and the parties would feel comfortable in the arbitrators using these tools. But perhaps we'll get into that later. Yeah.
David, you have a?
No, go ahead. I was going to say that based on the demographics of arbitrators, their age, and how tech-savvy they are, we might be the least, the slowest one to embrace that technology. And perhaps it could be the tribunal secretary that's the one that starts using it. Yeah. That's my guess.
Well, those of us who are relatively closer to retirement probably have a little less to worry about. It's the young generation that's really got to worry about how things look in 10 years and 20 years, and so they need to adapt, I think. Especially, they're going to be the market leaders in that. I think one interesting area in which we're going to see AI get used, and it's something of an obvious one, but I think rather fundamental in a sense that the quality of a submission in terms of its language, its ease of reading is a very important one, and lawyers devote years to develop the craft and to hone it. Law firms hire people with these skills for this very purpose, and I think in very rapid order, teams that have maybe don't have native English speakers, maybe lack in sophistication in some sense, or their submissions are going to radically transform in quality, ease of reading, clarity, and I think that's going to change the market in a way that I haven't really heard people talk about.
Okay, because when I see the market demand, I would say some users say, I want quick resolution. Somebody have bad experience with arbitration in particular, at a longer period, or some unacceptable to them result. They just say, why don't you have some quick decision where somebody knows all the case precedent and all the information, or even, for example, everybody in this room have expressed some views on these certain issues. The collective view was actually decided the issue immediately without have any particular person review the documents, analyze evidence, and make a decision, because the market want the quick decision and move on after that. We lawyers are serious about the legal analysis, whether it's accurate or not, but business side may want just quick decision about the case. Then how we overcome the problem? I mean, I'm not saying problem, but it's a big problem to our whole business. And we don't need lawyer anymore, and then we don't need any, maybe institution also have a threat, because you have as soon as you have submission, you can immediately have the result, and then all the process can be used by avatar rather than actual person. And so that if the market have such a strong demand, how we prove that the human beings are better, or the human factor should be there? John, you already mentioned something about a bit of why we need human being.
It's more a hope than anything. I think, not being able to predict the future, but I think those cases, Kevin, will be the first ones that come through, where people want, and maybe it's not a huge amount in dispute, and people want something quick, maybe not perfect, and there is going to be some company that is going to provide a service that says you can come here, and there already is. I think they're being sued in the US, but they will say you can just put your data in here, and again, the problem is the prompting, but you can do that, and something will come out. Yes, no, you, claimant or respondent, and how much. And that'll start. I have no doubt about that. There's nothing we can do to stop it. There's going to have to be rules and regulations around it. Us being lawyers and sitting on top of some mantle and saying, we must have these rules and stuff. We're going to be outvoted by the number of people who are not lawyers who think we make too much money and whatever else already. I think with arbitration, the problems that we have, that we know, I remember when I started, I can tell a client, or at least my partner at the time could tell a client, is cheaper and faster than litigation. It's very hard for me to say that now, because it's sometimes not true. And so we need to go back, I suspect, in a market challenging world where there's an alternative that we might poo-poo, but it will exist, to say there's better value here. But the ultimate better value is that there's a correct decision that comes out, taking on board all the issues maybe not things just within an algorithm or within some space that we don't see. Now, I just have a very quick funny story. My kids are very young. They're applying to school in Hong Kong. It's a terrible nightmare. No one should ever do that. The parents get interviewed for the first time. It was an AI bot interviewing my wife and I, right? So before, it used to be online or in front of someone. It was like the Kevin bot type person coming and saying, and they've reviewed our application. So the questions were pretty like spot on, which was kind of scary. But also just something maybe in 20 years time, and my kids grow up and that's normal, I don't know. But it didn't feel right. It didn't feel right. And I suspect when you have not just justice, but a feeling that there's justice being done, which I think as humans, as a base feeling is important. I think that's the kind of thing where we human beings, all 7 billion of us, can provide a better alternative to just them pressing a machine.
Okay, thank you very much. Yes, Matt?
Yeah, I think there's a lot there, and just sort of two broad points. First of all, we heard some discussion in our first session about so-called quick and dirty solutions. Somebody who does a lot of construction, I'm actually quite a fan of quick and dirty solutions, and I think a lot of users are as well. To go to John's point, I mean, we as lawyers and arbitrators often engage in a certain kind of pearl clutching when we talk about approaches to dispute resolution that we feel kind of invade too far and maybe undermine to too great a degree our sense of what's appropriate from sort of a due process point of view. But I think in many cases, and it's not just the low value cases, it could be very high value cases where the issues are straightforward or the clients just need a quick resolution. They could be quite happy to put those, to sort of sacrifice a bit of due process or whatever value that lawyers are contributing. And I don't mean to sort of downplay that value, but nevertheless, it just might be a secondary consideration. That's the first point. Second of all, we're going to see, and when I get to my slides, you'll see some, what I'm going to call kind of bromides to the continuing importance of sort of the human element. And we can cling to that. Like some people cling to guns and religion, right? We heard about that. We can cling to the human element in this context. But I think that we should be open-minded, and we should accept that we don't really know what the future holds. We don't really know what the potential of these tools will be. And so we might recognize a kind of a categorical distinction now between what the humans can bring to this process and what the AI may, and that might change over time. So I think that's just a general point. Yeah.
Okay, David?
Yeah, I think that all this is just going to happen, of course, inevitably and organically. It's going to start on the easy cases, and there's going to be some errors and some headlines, and then it's going to kind of work, and it's going to settle in, and it's going to expand, and it's going to get more sophisticated, and we're all going to adapt and get used to it in certain categories. And once that confidence builds, it will continue to expand. And yeah, the lawyers, do we adapt? Do we get replaced? It's a little bit of a question, but I wanted to add an interesting point on the institutional future, because I think that's a different question than the lawyer question. And how do the institutions adapt, take advantage of the situation? And a key element in this whole discussion of AI is data. You've got to have large data sets. ChatGPT works as well as it does because it's a large language model basis. How do we do that in international arbitration? That's a big challenge. Litigation, a system like the UK or the US, you might have a sufficient data set to get started. Arbitration is a little different. Now, who has that data? Arbitration awards and what's going on behind the scenes. The institutions do. And I think they may have an opportunity to take a lead. And if they wanted to be very proactive and collaborate and share a black box database of awards that are not accessible to humans but only the AI, you might be able to generate some real interesting, usable AI databases.
Okay. Maybe you can, think about something else. It's a bit related to the separate issue. We have third-party funding now very popular in some jurisdictions. We have similar discussions whether it's allowed it, not allowed it, whether it's work or not, is ethical or not. So, David, could you explain about what happens in third-party funding?
Thank you. I had the luck of being given the topic of third-party funding, which just a few years ago was the hot topic at every conference, and it's now been completely replaced by AI. So I will see what I can do to maybe connect the two in this session. Where does third-party funding, which TPF for short, where does third-party funding come into the picture in the question of this session, which is keep up or perish? Keep up with third-party funding or perish? What kind of even question is that? It's an interesting one, and actually I think it's got a very interesting potential answer. And I'm going to hit 3 points. I'll try to do so briefly. First one is that third-party funding has a very rapid rise and very recent across many jurisdictions, including the Asia Pacific. The second point is going to be that third-party funding it's not simply the question of funding or not of individual cases. The services have become very diverse and evolving. I think that's going to matter. And third-party funding is also likely to play an important role, I'm going to propose, in the evolution of dispute resolution, including the application of AI. So the first point, just to quickly cover the ground, which I suppose we all might be roughly familiar with, but it's worth noting that all of the development of third-party funding in which across Singapore, Hong Kong, and Australia, fully legislated systems to incorporate, allow, permit, and enable third-party funding. China and India, legislation lacking, but court decisions suggest favorable views, a lot of activity in both jurisdictions. Korea and Japan, a little bit still reluctant. There are some questions about whether it's allowed or it might run afoul of certain laws and regulations, but nonetheless, reports are that Japanese and Korean parties are frequent users in other jurisdictions, usually. Although that said, I'm aware of at least one case of a Japanese court litigation that's been funded. So things are evolving. The second point that I want to make, expanding third-party funding services. Apart from individual case funding, there is kind of portfolio funding, and a lot of major law firms or corporations can take advantage of that, where you just get a pool of money to just draw on for various disputes as needed. Enforcement. And I can talk a little bit more about this, but I think third-party funders are uniquely well-positioned to look at enforcement from the assessment, assistance, outsourcing, and risk buying of enforcement. That means they can just buy the award from you and at a percentage basis, or they can outsource to experts, or they can be the expert to enforce. Very flexible. They can handle this part or that part of a dispute that might be needed, operating costs, early assessment costs, security for costs. And an additional soft benefit, which I think comes with third-party funding and increasingly may be true, is that once you've had a third-party funder that's got its own money on the line and has done a very thorough and detailed analysis, that there may be a certain impression to the counterparty that this case, the case that's being funded, might have some real merit, and you might be a little more nervous when you go into negotiations with that. The third point, I think this is maybe the more speculative but perhaps interesting one. Third-party funders have a very high incentive to assess accurately and to recover successfully. They maximize the assessment accuracy through their in-house expertise, and they tap other resources, including lawyers and external law firms. As AI develops, I think they're going to increasingly use those tools as well. And as I mentioned earlier, the access to large data sets is critical to good assessment if you're going to rely on AI to do that. And I think third-party funders, especially the bigger ones, are ones that are gathering data. And they are, again, like the institutions, in a position to vacuum up information and data from the beginning to the end of the process. Think about this for a moment. What are the skills, the expertise, and the incentives with regard to these three players, the client, the lawyer, and the funder? The risk level that they assume, the incentives with regard to various periods, including assessment, win, and recovery, expertise with regard to assessment process and recovery. Well, the client has got a lot of high risk level. It's their dispute. They have strong incentives on assessment, win, and recovery, not a lot of expertise. The lawyer, not a high risk level. It's some reputational issues, but it's mostly behind the scenes. They're going to get paid, usually, regardless of outcome. And so the incentives are a bit different. And expertise, of course, excellent with assessment process and maybe good on recovery as well. But it's not the bread and butter of the lawyer's work. The funder, on the other hand, now dispute is a distraction from the business of a client, but it is the business of a funder. So they've got very high level risk, incentives, and they will tap the resources they need for the expertise. What that means is, I think that as AI continues to develop, third-party funders are going to be in a very interesting position to capitalize and lead, be sort of early adopters for all of that. And lastly, I'll just say, like, the current status is that there are, as I think was mentioned, there are startups that are beginning to use AI and project outcomes. It's usually early stage, not terribly reliable. But interestingly, the early client base for these startups are third-party funders and insurers. These are the entities that are looking to tap these developing technologies. As I mentioned, it's hindered by a lack of large data sets, but third-party funders are in a unique position in that way. The last thing that I would just say is, like, the outlook for AI in terms of usage by TPF. Today, as mentioned, I have a couple of quotes here, and I won't read them out for the sake of time, but key people at key top-level third-party funders who both say, look, right now, we're watching AI, we're seeing what it can do, but we're still very heavily reliant on lawyers for the moment. So we're safe for now.
Thank you. May I ask everybody, just how many of you involved in arbitration with the claimant third-party funded as arbitrator or counsel? How many of you involved? So I see many hands already. Then I understand Hong Kong and Singapore is specifically allowed, third-party funding is specifically allowed. So could you share with your experience with third-party funders?
Yeah, it's allowed now. You just have to disclose that it's being funded. In litigation, I think recently, well, I don't think we're allowed in litigation yet, but arbitration, yes. Yeah. So we're at the forefront.
So I thought that, maybe the third party, when they think about AI, we can think about similar type of the service that we haven't used before, which is third party funding now is frequently used, and that is as long as it's disclosed. It's like AI. When you use AI, then AI was the tribunal can use that. We are going to use the AI on this point. They really threat an expert industry. So that then we going back to the issue, how much AI can replace the human elements in arbitration? So Matt, could you elaborate a bit on the issue?
So I have been asked to kind of tee up this general topic, and I've tried to do so in a way that will perhaps kind of create the foundation for some discussion, both here within the panel, but more broadly with our distinguished audience members. And, I think that it's important to state at the outset, I don't have the foggiest clue as to whether, and I suspect actually that's not quite right. That's maybe honest, but actually in first looking at this question, I mean, I think I probably answered it as I suspect many of you will be doing right now, which is with a kind of a less than fully confident no way that AI will replace human arbitrators. And I think that's probably as it should be. Because there are good reasons to think, as we've discussed some of them already, that the human element is fundamental. It may be essential in this aspect of, in arbitral justice. Probably. I think that we should also have a healthy kind of, as I mentioned before, sense of humility about this, and I think that we should never underestimate the potential of AI to have a very disruptive and maybe to the good impact in international arbitration as it is having in many other areas of economy and society and human endeavor. So anyway, to grapple with this question, I asked some AI chatbots what they made of this. So here is the response that I got from ChatGPT 3.5. And you see that the bot refers to various ways in which AI could assist arbitrators in doing their work, streamlining administrative tasks, facilitating research and information gathering, maybe even assisting in decision-making processes through providing information and analysis. We've talked about some of these elements. I think those potential benefits are reasonably well known. However, ultimately, this bot concludes that it's unlikely that AI will completely replace human arbitrators because human arbitrators supposedly possess qualities such as empathy and the ability to consider ethical aspects that AI lacks. Okay, hopeful. That's ChatGPT 3.5. I then looked at 4.0, and I'm struck here that this bot seems to be gaining confidence in its future and its capabilities, because now suddenly we see references to understanding of emotions, intuition, judgment based on personal experience, ethical considerations that AI currently lacks. And I think there's maybe a lot turning on currently there. And then the suggestion that, replacing humans entirely might still be far in the future if it happens at all. So whereas we might have in a ChatG 3.5 stage been sort of quite confident that we're okay for a while, here we're saying, well, maybe just a matter of time. So, in the interest of neutrality, I also looked at the Google bot Bard, and I found something which was very, very similar, kind of AI likely to play an increasingly important role in arbitration in the future. But still, what I thought was interesting here is, AI can analyze large amounts of data, identify patterns, those predictive abilities. They are amazing and they could be used in many ways, but they still lack the ability to understand human emotions and motivation. Never will. So I think we need to look at that, and that here, at least in this account, that ability to understand human emotions and motivations is said to be essential for making fair and impartial decisions in arbitration cases. So I think that's somewhat reassuring again. And on that basis, it's unlikely that AI will completely replace human arbitrators. They'll still be needed to provide the human touch, right, and to ensure that arbitration remains a fair and impartial process. So I have actually, though, some skepticism about that, as I mentioned. I think that we shouldn't underestimate the technology, and it may not be too long before we have something. I mean, already ChatGPT 4.0 feels so much more kind of human than 3.5. And I think we should really watch this. Now, I have listed here on the screen a number of kind of what I'm going to refer to as threshold issues, just to sort of, we can kind of think about and maybe talk about. One, first of all, is resistance a viable option? We can talk about it. I heard a little bit of resistance in the sort of, directives that Hawking proposed earlier. But, I think we can talk about that. I suspect at the end of the day, no, resistance is not a viable option. It's probably a fool's errand, and what we need to do is accommodate and adapt. I think that's going to be the general message, right, of the conference. Then, what sort of justice do the parties seek? Now, I made a reference to this earlier, so I won't tarry, but, it may well be that we're talking about horses for courses, and there are many, many disputes in which clients are quite happy to say, whatever AI can do for me, I want it. And others where we'll say, no, we want a very traditional sort of, old school approach, and we'll work all this out in practice. We talked about legality, and there are many, obviously, regulatory issues surrounding AI that we're going to have to grapple with. Again, as I said before, I don't think that these are going to prevent us from using AI over the longer term. Accessibility of advanced AI. Now, I think that there's a kind of an assumption in a lot of the talk about these AI tools that, oh, this is all going to make arbitral justice more accessible to people. Now, I think that's probably true, but I think that there may also be a sense in which there's quite a gap between the best AI tools that are going to be developed in the future and what we saw Hawking searching through in that presentation, which is great, right? But maybe that's a kind of a Sonata, and there might be other tools which are more like a Ferrari, and then we might see another kind of digital divide open up around that. I've heard this view mentioned in other discussions about the topic, so I think it's something to pay attention to. Obviously, transparency, particularly when you're talking about arbitrators, is quite an important one to bear in mind. I think that could be quite thorny in practice. As a user of arbitration, as a counsel, I would very much want to know exactly what use of AI my arbitrators was making, precisely in what way, and to what end, and to what effect. And then you can imagine that means that there's going to be demands for disclosure if there aren't already requirements in regulations and in guidelines. But you can imagine that when those disclosures are made, they could be quite contentious, and there could be a lot of discussion and ventilation around them. So I think that's something to watch. Also, just to get some issues up on the table, obviously we've got potential benefits of AI to arbitrators. We saw references to these in those chatbot responses. I won't discuss them except just to maybe mention drafting arbitral awards, there's going to have to be a lot of discussion about how far we go. And probably that discussion is going to be looking at what do we allow arbitral secretaries to do now, and why should it be any different? Maybe there are differences, and then what are the arbitrators doing with the drafts? I mean, obviously, preparing a procedural background section should be pretty straightforward. That's obvious. We're going to let the AI do that. Preparing summary of relevant facts. Yeah, we're probably okay with that, but there's going to have to be quite a lot of scrutiny, and we want the arbitrators to be selecting those, or to feel that the arbitrators have vetted that very, very carefully. And then when we get into the sort of decision analysis, I think it's obviously more difficult there, right? There was a reference in one of those to, I think the Google chat box said that AI may well be able to innovate procedurally and to come up with alternative kinds of arbitration. Well, okay, we'll see. It's maybe something to watch. Finally, some potential drawbacks and concerns. Won't go into detail. We've heard discussion already about limitations bias in available sets. Obviously, we have the ICC now publishing awards, anonymized awards, quite systematically. So it may be that over a matter of decades, we will feel much better about our data set. But as of right now, I don't think we have a very good extensive data set in arbitration, and that's a basic limitation that we're going to have to grapple with. Also think David made a reference to disparities between the extent to which different jurisdictions have made their law, their authorities available, right? And I think that in many cases you will see a fundamental distinction between common law jurisdictions and civil law jurisdictions on that point. So what does the chatbot do? Do they just, or what does the AI tool do? Do they just kind of revert to what's available? And if so, is that going to result in some sort of a biased or distorted review? So I think that's something to watch. I've already talked about the human element. Is that a real thing? Black box problem. We know that AI, as it currently exists, is not really good at explaining its reasoning. And yet, when we think about an arbitral award, an effective arbitral award, we know that one of the basic features of a good arbitral award is that it explains to the losing party why they lost. And hopefully in a way that the losing party can understand and accept, even if they don't agree with it. And that also contributes to the legitimacy of arbitral justice, doesn't it? So if we have, if this evolves in such a way that we have decisions which may be, in some ways very reliable, maybe very well-received decisions broadly, but that never are really able to explain the reasoning, is that going to be an acceptable form of justice? Is that going to be a legitimate form of justice? It's obviously something to watch. So I'll pause there.
Thank you, Matt. Maybe I can ask you, how many of you support the idea that still arbitration should be done by human being only? Oh, some people still support AI only, or maybe have no intention to participate. I think, you talk about database or platform. How much UNCITRAL is having any intention to create UNCITRAL AI to assist or do something in arbitration? I'm not sure whether you're authorized to say something on this issue.
All views are personal. Yeah, all views are personal, institutional. I don't think we've ever received this question. Again, technological neutrality. What do we use? Also, as an international organization, we need consent, I think, for that. Like any other UN deliberation, it's a bottoms-up process. We need member states to deliberate and then decide how it should go forward, as it is with all institutional proceedings in UNCITRAL in the United Nations. But it's intriguing. I think for me personally, I think the threshold question, having been with the UN now for almost 5 years, is whether AIs will replace translators. Because in the UN we have 6 official languages. It's very hard. Our translators are fantastic, of course, but you know, it's difficult to use them all the time. So when we were able to do it informally in one of our conferences, not just to Chinese, they also tried Korean to Chinese. It was able to do it almost instantaneously, of course, with the use of human prompters. So I think I would stop there at my non-answer. Also, seeing Jay's face there, I'm reminded to tell you that we're working on, UNCITRAL is working on, we're looking at third-party funding as well in the context of Working Group 3. Is that, yes, yeah.
Okay, if you think about the combination of third-party funding and using the AI, then again, from the market, users might want just evaluate claim based upon the AI, and using the third-party funding. It's more like a finance the claim rather than just claim as illegal meanings. It's quite tempted that the business side okay, I want just to resolve the issues through using certain AI. Of course, it's like a caveat that is data is fair and there's many things, but maybe they can easily catch up with that issue. But still, we have a fundamental issue. We don't want to be governed by AI, which we notice a lot in the movie. But as soon as we just hand over the authority to decide, like resolve our dispute by AI, then that is governed by AI. So we have a very, very serious issue. And then we now talk about this issue in every conference, but we don't have a right answer right now. But this is a good time to think about AI and how we use AI. How we use AI can assist arbitration rather than just delete arbitration, you know, in the dictionary. So the beauty of a human being is we are flexible. We just see the circumstances. I see that the fatigue after lunch, you know, without mentioning my AI's joke, we started a bit late. We can give you more time for the break, for you talk more about AI, you know, among yourselves. So I can finish this session as a human being earlier than we originally planned it, unless anybody have objection about it. Thank you very much.
So yes, that brings us to the end of session 2 of the 12th Asia Pacific ADR conference titled Keep Up or Perish, Practitioner's Dilemma in the New Digital ADR Age. Thank you very much. And now you may go back to your seats. Ladies and gentlemen, please give them another round of big applause. Thank you very much. And now we will take a short break for about 10 minutes.